Hello aspirants, here I am Pallavi Raya. Today we will talk about the important rule of order 8, which is set-off. Rule 6, which talks about set-off. In earlier video we have discussed about the only a part of written statement, but we had not discussed the rule of set-off or a counterclaim. So we had said in that video that we will make another video on set-off particularly. So today we will discuss about the set-off. Actually, where a suit for recovery of money by the plaintiff and the defendant find that he has also a claim of some amount against that plaintiff, he claim a set-off in respect of said amount. What the meaning of set-off here? The meaning of set-off is the reduction or discharge of a party's debt or a plaintiff's debt or a claim by an assertion of defendant claim arising out of another transaction or a cause of action against the other party. So set-off is a reduction or a discharge of another claim. So rule 6 talked about set-off. And the doctrine of set-off may be defined as the extinction of debts of which two persons are reciprocally debtor to one another, by the credit of which they are reciprocally credited to one another. Thus, it is a reciprocal acquittal of debt between two persons. So, this is the doctrine of set-off. Rule 6, obviate the necessity of filing a fresh suit by the defendant. And when defendant pleads set-off, he is put in position of plaintiff as regard the amount claimed by him. A defendant may claim a set-off even if the plaintiff's suit is dismissed. So, the rule 6 of order 8 deals with rule of set-off, and set-off is the reduction and discharge of parties' debt of another claim, by an assertion of another claim, which is arising out of another transaction. And defendant should present a written statement for the claim of set-off at the first hearing of the suit, but not afterward unless permitted by the court. So, defendant may claim set-off if the following conditions are satisfied. First condition is the suit must be for the recovery of suit in a negotiable instrument. A suit for dissolution of partnership or for account is not suit for money unless there is a prayer for payment of balance. So, second condition is the amount claimed to be set off must be a certain sum of money and legally recoverable. Third condition is it must be recoverable by the defendant or by all the defendants from the plaintiff or from all the plaintiff. Fourth condition is it must not exceed the pecuniary jurisdiction of the court in which the suit is brought. And the last condition is both the party must fill in the defendant's claim to set off the same character as they fill in the plaintiff suit. So these are all the conditions which must be fulfilled, and if these conditions are satisfied, so thus the defendant may claim a set-off. Now we will see the effect of set-off. Effect of set-off is given in sub-rule 2 of rule 6. The sub-rule 2 says that the written statement shall have the same effect as a plaint in cross-suit, so as to enable the court to pronounce the final judgment in respect of that original claim and of the set-off. But this provision under sub-rule 2 does not affect the lien upon the amount decreed of any pleader in respect of cost payable to him under the decree. And sub-rule 3 says that the rule relating to written statement by a defendant apply to a written statement in answer to a claim of set-off. So the effect of set-off and the rule regarding the written statement is the same, and effect of set-off is the effect as we file cross suit in a plaint, so that we file counter claim or a set-off in original claim. So plaintiff file a plaint and defendant file a cross suit in respect of that plaint. Same as in case of claim for recovery of money. Defendant had claim for set-off. The effect of written statement in case of plaint or a cross suit, it will be the same with original claim as well as set-off. So this is the effect of set-off. And rule of written statement by the defendant will be the same in answer to a claim of set-off. So this is all about rule 6 regarding the set-off. There are some illustration annexed with this rule, so we will discuss one or two of its illustration. First we will see that, so the first illustration is A and B sues C for 1000 rupees. C cannot set off a debt due to him by A alone. What does here means? If both the party A and B both has the debt of C, then C can set off a debt due to them. Otherwise, he cannot set off a debt due to any one of plaintiff alone. Let's see another illustration. A sues B on bill of exchange for rupees 500. B holds a judgment against A for rupees 1000. The two claims being definite and pecuniary demands may be set off. So this is the illustration of set off. So rule 6 deals with legal set off only, which was allowed by the court of common law, and it doesn't deal with equitable set off. So while legal set off can be claimed as of right, but equitable set off is depend upon the court's discretion. So it should be noted that equitable set off is recognized under Order 20 Rule 19. So Rule 19 says that decree when set off or a counter claim is allowed. So we are here discussing about set off, so we will discuss about the rule of set off. So Rule 19 says that where the defendant has been allowed a set off against the claim of plaintiff, the decree shall state what amount is due to the plaintiff and what amount is due to the defendant, and shall be for the recovery of any sum which appears to be due to either party. So Rule 19 sub rule 1 says that when defendant will be allowed and what sum is due and due to what sum is due to the plaintiff and what due to the defendant, what will the recovery of any sum, this all kind of provision is given. Rule 19 sub rule 2 says that appeal from decree relating to set off. Any decree passed in a suit when set off is claimed shall be the subject to same provision in respect of appeal to which it would have been subject if no set off had been claimed. What does here means? That the provision of appeal is the same in respect of set off as well, and the provision of this rule shall apply whether the set off is admissible under Rule 6 of Order 8 or otherwise. So the Rule 19 of Order 20 deals with the decree when set off is allowed, appeal from decree relating to set off, and the provision of this rule shall apply whether the set off is admissible or otherwise. So this is all about set off, and there are many illustrations. You can read it from Barrett today. That